A tradie in Western Sydney comes home on a Tuesday. There's a notice taped to his front door. His bank accounts have been frozen, his ute has been restrained, his house, the one that his kids grow up in, can't be sold, mortgaged or transferred. Not by him, not by his wife. He hasn't been arrested and he hasn't been charged. In fact, he hasn't at any point been told what he's supposed to have done. And the body that did this to him isn't a court, and it's not the police. And under the law as it stands today, it can do this to almost anyone on the basis of suspicion alone. The New South Wales Crime Commission can seize your home, your bank account, your car, and they don't need to prove that you committed a crime to do it. Now you're already thinking, well, that can't be right, don't I need a conviction first? No. Under the Criminal Assets Recovery Act, assets can be frozen before you're charged and taken before you're convicted, on the civil standard of proof. And here's what makes this different from a court doing it. The Commission isn't a court, it's an executive body, which means the decision about whose assets get targeted starts in a room you will never see, with a process that you will never be a part of. And I'm going to show you why. Your first instinct, fairly, is probably this. This does not happen to ordinary people. This happens to bikies and drug syndicates. Yeah, sometimes it does. But I've spent my career on both sides of the system. First as a police officer, then a prosecutor, and now as a defense lawyer. And I can tell you, from the files that have crossed my desk, that the architecture of these powers does not stop at organized crime. Because the threshold to use this power is not, we have proven you've committed a crime. The threshold is not even, we have charged you. The threshold is suspicion, and suspicion as a legal standard does almost no work at all. So I'm going to walk you through three things. First, what the New South Wales Crime Commission actually is and where it comes from, because the origin tells you why it has the powers it has. Second, the three things it uses to take property from people who have not been convicted of anything. And third, the structural problem at the heart of it all, the question of whether the decisions about your property and your liberty should be made entirely by a court or by an executive body operating in a room that you're not allowed to enter. The New South Wales Crime Commission was created in 1985 under a different name in response to recommendations from a Royal Commission into Organised Crime. The premise and the promise was straightforward, and at the time it was defensible. The traditional criminal justice system, police investigate, prosecutors charge, courts decide, was struggling against sophisticated criminal enterprises that hid their money in layers of corporate structures and offshore accounts. The argument was, we need a body with extraordinary powers to follow that money. So Parliament created one. And it gave that body something the police don't have, and something the courts don't normally allow. It gave the power to compel testimony. It gave it the power to operate in secret, and critically, and this is where I want you to pay close attention, it gave it the power to seek orders against your property on the civil standard of proof, not the criminal standard. Now, you've heard the criminal standard before. I've said it many times. Beyond reasonable doubt. And it's the highest standard in our law. It exists because we, as a society, decided a long, long time ago that taking someone's liberty is so serious that we would rather let 10 guilty people go free than convict one innocent person. The civil standard is not that. The civil standard is the balance of probabilities, more likely than not. It is the standard that applies when you sue your neighbour over a fence. And the New South Wales Crime Commission can take your house on the standard that you would use to sue your neighbour over a fence, without ever charging you with a crime. The instrument that does this work is called the Criminal Assets Recovery Act. It sits in New South Wales legislation and it gives the Commission three distinct mechanisms to move against a person's property. They are designed to interlock. They are designed to be used together. And they're designed, and this is not a contested point, this is the explanatory memoranda when the Act was passed, to operate independently, separately, to the criminal justice system. So Parliament has been very clear about this. This is not connected to the criminal system at all, even though it deals with criminal subject matter. This is the phrase that should make you pause, independently of the criminal justice system, the system that has juries, the system that has the presumption of innocence, the system that has the Crown bearing the burden of proof beyond a reasonable doubt. This Act creates a parallel and separate track that doesn't have any of those things. So let me take you through the three mechanisms. The first mechanism is the restraining order. So this is the freeze. The commission applies to the Supreme Court, and yes, a judge does sign the order, and that's a point that I'm going to return to in a moment. And the order prevents you from dealing with your property. That means you can't sell it, you can't mortgage it, you can't transfer it. Spending the money in your accounts beyond limited living expenses, which the commission itself will determine for you. Here is the threshold for that order. The Supreme Court must be satisfied that there are reasonable grounds for the Commission's suspicion that the person engaged in serious crime-related activity. It's probably worth going over again. The court is not deciding whether you actually engaged in serious criminal activity. The court is deciding whether the Commission's suspicion of that activity was reasonable. Your conduct, in fact, is not even being judged at this point. The court is reviewing the reasonableness of an executive opinion, a government opinion, about you. And the order can be made without you. In fact, more often than not, it is made without you and before you know it exists, before you know it's even operating. It's called ex parte, which means that the commission walks into court and presents only its material, and the order is issued. And the first you hear about it is when either the notice is taped to the front of your door, or, more often, when your card declines at the supermarket. You have no opportunity to be heard before your property is frozen. Your day in court comes after the freezing has already happened. And I can tell you this from the defense perspective, often it happens without people contacting someone's lawyer, even if there are already criminal proceedings on foot. So what this means is that your lawyer's fees are coming out of property that has been frozen, and the commission has months of evidence gathering capacity without you even knowing it's happening. So here is the first piece of the picture. Suspicion, not proof. Suspicion is enough to take the access of your property away before any charge has been laid against you, before any allegation has been tested, before you have had any chance to respond. And the body whose suspicion this is not a court. It's the commission. All right, let's go through mechanism 2. This is where the freeze becomes the take. Once an asset has been restrained, that's step 1, the one that you very rarely know is even happening. The commission can apply to the Supreme Court for what's called a proceeds assessment order, or an assets forfeiture order, or a we want to take your property order. And if granted, the property is permanently transferred to the state, meaning not yours at all, potentially ever again. Now, I want you to focus on the threshold for this, because this is where the architecture of all this really shows itself. The commission does not need to prove that you committed a crime. In fact, they don't need to prove that the specific asset was something that you got from criminal conduct, known as proceeds of crime. The commission needs to satisfy the court on the civil standard of balance of probabilities that you engaged in a serious crime-related activity at some point in the previous 6 years. Balance of probabilities, no charge, no conviction, no jury. And here's the part that when I explain it to clients takes them a little bit to get on board. Maybe not on board, but at least absorb it. Even if you are charged with a criminal offence relating to the same conduct, and even if you are acquitted of that criminal offence, the assets order can still be made, even if you're found not guilty, and it can still stand, because the criminal court was applying the criminal standard of proof, and the commission's application is being decided on the civil standard. The same conduct, the same facts, 2 different standards. One can clear you from a criminal charge, but the other one can still take your house. Now, this is not a theoretical concern. This is the design of the act, and it was drafted this way deliberately. And the rationale given at the time was that the criminal standard was too high to effectively pursue organised criminal proceeds, criminal money, criminal assets, which may or may not be true, but the consequence of solving that problem in this way is that we now have a system where suspicion of conduct, which will not be tested by a jury, can result in the permanent loss of practically everything you own and everything that you would want to give to your children. The third mechanism is the most radical. It is called the Unexplained Wealth Order. This is the way it works. The commission identifies a person, let's say it's you. The commission examines that person's wealth, And if the Commission concludes that your wealth is more than can be explained by their lawful income, the Commission can apply for an order requiring the person to pay the difference to the state. Think of it like a retrospective tax. So what does that Commission have to prove? They have to prove that the wealth exists, that it appears to have exceeded your lawful income, and no, that's it. That's the Commission's case. What do you have to prove? Everything. The legitimacy of every dollar, the origin of every asset, the source of every deposit, where your cash came from the renovation in 2018, why your aunt left you money like she did, what your father gave you after your wedding. So the burden of proof is being what's called reversed. It's a reverse onus. You are now proving your innocence. This is the polar opposite of the criminal standard. Not of an offence, by the way. You don't have to prove that. But what you have to prove is your own wealth. That is, in many ways, significantly harder. And if you can't account for every dollar to the standard that the court is satisfied with, the state takes it. This is the inversion. So in criminal law, the prosecution proves your guilt. Under an unexplained wealth order, remember, civil, not criminal, you prove the cleanliness of your money. The presumption operates against you. And the further back the Commission looks, and they can look back years, the harder it becomes for any ordinary person to produce the documentation needed to discharge that burden, to prove it. Because most of us do not keep records of cash gifts from family members 15 years ago. Most of us can't prove the lawful origin of every dollar that has ever passed through our accounts. So the unexplained wealth power assumes that you can. And if you can't, then that failure of memory and paperwork becomes the state's basis to take what you own. Now, defenders of this regime will tell you the following. They will say, relax, a Supreme Court judge has to sign these orders. The court is involved at every step. There is judicial oversight. And yeah, that is technically true, but it's also misleading because all of the decisions that actually matter in this process, who's targeted, when they're targeted, what assets are pursued, how much is sought, when charges will or will not be laid. None of those decisions are made by the court. They are made inside the Commission. The court's role is to assess whether the Commission's paperwork, which they could have months or years to prepare, meet the statutory threshold. And the threshold, as I have just walked you through, is suspicion. So the court signs the paperwork. The Commission decides who it thinks the property belongs to. That distinction tells you everything you need to know. Because what we have in substance is an executive body, not a court, not a jury, not the police acting under criminal procedure, making the underlying decisions about whose property is taken from them. The court provides a procedural layer. Think of it like a filter. But the filter has rules and they're set out by the Act. It doesn't provide a substantive layer. And what I mean by that is that the court is not asking, did the person commit the offence? The court is asking, did the Commission have reasonable grounds for thinking that the person might have? And that is just simply not the protection most Australians believe the courts provide. And it is not the protection that the rule of law was designed to deliver. So let me bring you back to the tradesman from the start of this video and make it concrete. He runs a small construction business. He has over the years done some cash jobs. Most tradies have. He has a house in his and his wife's name that he bought 10 years ago and has substantially renovated himself with material he sometimes pays for in cash and help from family and friends over the weekends. He has a savings account that he's built up over 20 years. None of this is criminal, unless of course he wasn't paying tax, but let's assume that he was. All of it is normal, or at least accepted culturally. But the Commission has formed the view that he has associations that warrant a closer look, so they serve a restraining order. The house is frozen, the accounts are frozen, and he can't pay his subcontractors. The business begins to collapse within weeks. His wife can't access the joint account for groceries beyond a commissioned approved amount, so he hires a lawyer, but the lawyer's fees can only come from a separate carve-out that again, the Commission has to approve. Then the assessment hearing comes. The Commission alleges that the renovation costs and the savings exceed his declared lawful income over the last 6 years. So now, our tradie has to prove in court, on the balance of probabilities, that every dollar can be accounted for. the cash receipts from 2019 are gone. The mate who paid him in cash for a deck in 2021 moved to Bali. The wedding gift from his father-in-law, there's no paper trail. Who does that at a wedding? He cannot discharge the burden. And guess what? He can't prove it's legitimate because he never thought he'd need to. So he's not charged with any criminal offence, and he's not arrested, and he's not in any conventional sense accused of anything. Yet the state takes the difference. And guys, this is not a hypothetical. That is the operation of the Act, as written. And the only thing that distinguishes that scenario from one that ends with him keeping his house is whether the Commission decided to look at him in the first place. Now, if you've been here for a while, I've spent the last several months on this channel walking through different versions of the same structural problem. ASIO's compulsory questioning powers, the expansion of the hate speech framework, emergency fuel rationing powers. Each one deals with a different subject matter, but each one is identical in its shape and how the power operates. Each one moves a decision that used to require a court, a jury, or at least a charge into the hands of an executive agency operating on a lower threshold, with reduced oversight, and with consequences that can be life-altering before any traditional accountability mechanism gets near it. Suspicion is increasingly becoming the standard for our institutional landscape. The way in which the government is making these changes makes it very clear. And every time it expands, the explanation is the exact same. Organised crime, national security, community safety. Each one's a real concern, and each one used as a justification for a permanent shift in the relationship between the citizen and the government. So here is where I leave you. The New South Wales Crime Commission is not, as a matter of constitutional structure, doing anything illegal. This is entirely legitimate. This is the law. The question is not whether it's lawful. The question is whether or not it's right that an executive body applying the civil standard of proof can permanently take your property that the state could never take under a criminal procedure. And if you think that's worth knowing about, if you think that people in your life should know what the law actually permits before they ever come into a situation where a notice is taped to their door, share this video. Send it to the people who would probably tell you that it was not going to happen to them, because the entire premise of this regime is that it doesn't have to require anything having been done wrong. It only requires the Commission to suspect that it might have. And suspicion is a very small word for a very large power. I'm James Glissan, and I will see you in the next one.